The champagne glass in my hand had gone warm, and I remember thinking that was strange because everything else about that afternoon felt cold. The lawn behind the university chapel was full of families taking photographs, mothers fixing their sons' ties, fathers pretending they weren't crying, grandparents sitting in folding chairs with programs rolled up in their laps like scrolls. And I stood at the edge of it all, in a tailored charcoal suit, holding a glass of champagne I never intended to drink, an hour after watching my grandson cross a stage I had paid for without his family ever knowing my name was on the check. "Ma'am, I think you have the wrong event." That was my son's voice, Daniel's voice, 12 years older than the last time I'd heard it directed at me, but I would have known it anywhere, in any crowd, in any lifetime. "This is a private family celebration. I'm going to need you to step back from the reception line." He did not recognize me. My own son stood 3 feet away from me, in a suit that cost more than my first car, and he looked directly into my face, and he saw nothing. A stranger, an inconvenience, a woman who did not belong. If you've ever stood in a room full of people who share your blood and felt like the only ghost in it, I want you to stay with me for what comes next, because I promise you, it does not end the way you think. 12 years is a long time to disappear. It is long enough for a boy of 12 to become a man of 24. Long enough for a marriage to calcify into something unrecognizable. Long enough for a name to be scrubbed so thoroughly from a family's history that the woman who once answered to it can stand 3 feet from her own son and be told, politely, coldly, efficiently, by the very family that trained her in the art of being efficient and cold, that she does not belong. I did not raise my voice. I never did, not even at the end, not even when it would have been justified. I simply looked at Daniel and I said, "I have the right event, Daniel. I have always had the right event. You're the one who's confused about who's standing in front of you." His champagne flute tilted, just slightly, and something in his eyes shifted, the way water shifts a half second before it begins to boil. But I am getting ahead of myself, and if there is one thing 12 years alone taught me, it is patience. So let me take you back to where this really started. Back before the graduation, back before the silence, back to the dining room table of a house that no longer exists, in a family that called itself the Whitfields of Latimer County. 3 generations of lawyers, a firm with brass letters on frosted glass, and a woman named Eleanor, who spent 35 years believing that if she was quiet enough, careful enough, agreeable enough, she would finally be considered one of them. I was never a lawyer. That was the first thing anyone in that family ever needed you to know about me. I met Richard Whitfield when I was 24, working as a legal secretary at a firm 2 floors below his father's, carrying files up and down a marble staircase in shoes that pinched. And he told me on our second date that he liked that I wasn't like the women in his world, sharp-edged, competitive, always performing intelligence like it was a courtroom argument. I did not understand then that what he meant was he liked that I would never challenge him. I thought it was a compliment. I was 24. I thought a great many things were compliments that were, in fact, quiet warnings. We married within the year. I gave up the secretarial work not long after because Richard's mother made it clear, in the gentle, suffocating way that old money families make things clear, that a Whitfield wife did not carry files up marble staircases for other men. I raised our children instead, Daniel first, then Vanessa 2 years later, and I want you to understand something about those years because it matters for what comes later. I was good at it. I was good at being a mother in that house, good at hosting the firm's holiday parties, good at remembering which senior partner's wife needed to be seated away from which other senior partner's wife, good at smoothing every rough edge in a family built entirely out of rough, competitive, achievement-hungry edges. I was the soft material packed around something hard, and for 35 years, I told myself that was a kind of importance. I did not yet understand that soft material is the first thing you remove when you decide the hard thing needs more room. "You were never fit to be a Whitfield." Richard said those words to me on a Tuesday evening in October, in the study of the house we had lived in for 2 decades, and I remember every detail of that room. The smell of his cigar smoke soaked into the drapes, the low amber light from the desk lamp, the way his voice did not rise even a single register because rage, in that family, was always delivered in a whisper, never a shout. Shouting was for people who had lost control of the argument. Richard never lost control of an argument in his life, not until much, much later. You're probably wondering what I had done to earn that sentence. It is a fair question, and I promise you, I asked it myself for years afterward, turning it over and over like a stone I could not stop touching. The truth is almost disappointingly simple. My father, Walter Callahan, a man who built a modest fortune out of undervalued real estate and stubbornness, died that September. And in his will, in a single clean paragraph drafted by an attorney Richard had never met and could not intimidate, my father left the bulk of his estate not to me outright, and not to Richard's firm to manage, and not, pointedly, to either of the 2 grandchildren who had already taken the Whitfield name into a courtroom, but into a single, irrevocable trust for his only great-grandchild, a boy of 12 named Ethan. Every dollar of it held, until that boy turned 25, by exactly one person. Myself, named as sole trustee. Sole trustee. Not Richard, not Daniel, not the firm. Me. You would have thought I had committed a felony in that study, the way Richard reacted. He wanted control of that trust the way a drowning man wants a rope. Not because the family needed the money, they didn't, but because in a household where every single person had a law degree except me, that trust was the one piece of paper in the entire world where my name outranked his. I did not understand at first how much that would cost me. I offered compromises. I offered to let the firm advise on investments, to let Richard review the accounting quarterly, to do anything short of handing him the keys outright, because my father, in his stubborn Callahan way, had written the trust specifically so that no Whitfield hands but mine could touch it until Ethan turned 25. My father, it turned out, had seen something in that house that I had spent 35 years refusing to see. Within 3 months, the story being told about me at every family dinner, every firm holiday party, every hushed phone call between Richard and his sister was that I had become unstable after my father's death. Erratic, difficult, not the woman they had married into the family. I remember the exact dinner where I first heard Vanessa, my own daughter, 32 years old and already a partner at her father's firm, use the word unwell to describe me to a table of relatives, as though I had a diagnosis instead of a trust document with my name on it. Here is something I have learned about families of lawyers, if you'll allow me the observation. They do not fight the way other families fight. They do not throw plates or slam doors. They build a case. Quietly, patiently, over months, they build a case against you, gathering small moments, misremembering conversations, reframing every past kindness as evidence of some hidden defect, until by the time they are ready to present it, the verdict feels inevitable to everyone in the room except the person on trial. I did not know I was on trial until the verdict had already been reached. The divorce papers arrived on a Friday in February. Richard did not hand them to me himself. A process server did, at the front door, in front of our neighbor, stopped on her own porch with her terrier on its leash. And I remember standing there in the cold, with a manila envelope in my hands, watching Mrs. Kessler pretend not to see, and understanding, in one single terrible moment, that this had all been planned with the precision of a closing argument. The custody arrangement for Ethan, my grandson, then 12 years old, Daniel's son, was never something I had legal standing to fight for directly. But the family closed ranks around that boy so completely, so surgically, that within a year I could not get a phone call returned, let alone a visit approved. Vanessa told me, the last time we spoke on the phone before the silence became total, that it would be better for everyone if I didn't confuse Ethan by staying in the picture. Better for everyone. As if I were a stain to be lifted out of a photograph. I left that house with 2 suitcases, my father's trust documents, and absolutely nothing else. Because everything else, the furniture, the china, the framed photographs on the staircase wall, had somehow, in the space of a single winter, stopped being mine. Richard kept the house. Richard kept the firm. Richard, astonishingly, even managed to keep most of our mutual friends. Because when a man like Richard Whitfield tells a room full of people that his wife became unwell after her father died, very few people in that room are inclined to ask for a second opinion. That I did one thing right that winter, and it is the only reason there is any story left to tell you at all. The morning after the process server came, I drove 90 miles to a lawyer in a county where the Whitfield name bought absolutely nothing. And I made her walk me through my father's trust instrument, clause by clause, until I understood it better than Richard ever had. Then I moved the trust banking relationship out from under every institution in Latimer County where Richard had a friend or a golf partner. And I had the original documents placed in a vault with a single signature card on file. One name on it. Mine. Richard's lawyers petitioned the probate court twice that spring to have me removed as trustee, on the grounds that I was not well enough to serve. Both petitions failed. My father had written that instrument so tightly that not one judge who read it could find a seam anywhere to pry open. I was 60 years old, and I had exactly one thing left in the world that no one could take from me: a trust document, and a promise I made to myself in a motel room outside of Latimer County, on a mattress that smelled like bleach, with my hands shaking so badly I could barely hold a pen. I promised myself I would not become the woman they had already decided I was. That promise turned out to be the most expensive thing I ever bought. And I do not mean that in dollars, though God knows it cost those too. It cost years. It cost the version of myself that still believed, somewhere in the back of her mind, that if she was patient enough, the people who loved her would eventually come back and apologize. I want to tell you now, so you don't spend the next hour waiting for that version of the story, that no one apologized. Not for a very long time. What happened instead was slower and stranger, and in its own way, far more satisfying than any apology could have been. But it started with a decision that terrified me more than the divorce ever did. I was 60 years old, living in a one-bedroom apartment above a dry cleaner in a town 2 hours from everything I had ever known. And I enrolled in law school. I want to be honest with you about how that sounds, because I know how it sounds. It sounds like a woman rebuilding herself out of spite. And for the first semester, I will admit, that was probably true. I sat in a classroom full of 23-year-olds who called me ma'am without a trace of irony, and I studied contract law at a kitchen table that wobbled unless you wedged a folded napkin under one leg. And some nights, I cried so hard over property law outlines that I couldn't see the page anymore. But somewhere around the second year, the spite quietly turned into something else, something closer to purpose. You might wonder why a woman who had just been legally and emotionally dismembered by a family of lawyers would choose to become one herself. I have asked myself that question too, more than once, usually at 2 a.m. with a law book open on my chest. The truest answer I can give you is this: I did not want to become like them. I wanted to understand the language they had used to erase me so thoroughly, so completely, so that no one could ever use it against me or against anyone else I loved again. There is a particular kind of power in knowing exactly how a weapon was built. It stops being frightening the moment you understand its mechanism. I did not specialize in family law, though everyone assumed I would. I specialized instead in something far more obscure and, as it turned out, far more useful: legal ethics and fiduciary compliance. The rules that govern how attorneys are permitted to handle other people's money, other people's trusts, other people's futures. I spent my third year of law school clerking for a disciplinary counsel's office, reading case after case of attorneys who had done exactly what my former family had tried, in smaller ways, to do to me: commingle funds that were never theirs to touch, exert quiet control over money that belonged to people with less power in the room. I graduated at 63, near the top of my class, and I did something that surprised everyone who thought they knew me, including, for a while, myself. I did not go into private practice. I went to work for the state. It took 4 more years of unglamorous, meticulous, often thankless work, reviewing trust account audits, sitting on disciplinary panels, writing opinions that maybe 40 people in the entire state would ever read, before the governor's office called me about an appointment to the bench. Judge Eleanor Callahan. I dropped the Whitfield name the same week I filed for divorce, quietly, without ceremony, the way you'd take off a coat that had never actually fit. My father's name on the door of a courtroom. I think somewhere he would have found that very funny. But I want to tell you about the part of those 12 years that mattered more to me than any title. Because titles, I have learned, are the least interesting kind of power a person can hold. Every single year, on Ethan's birthday, I wrote him a letter. I did not know, most years, whether those letters ever reached him, whether Daniel or Vanessa intercepted them at the mailbox and threw them straight into the trash, whether Richard had instructed the whole household to treat any envelope with my handwriting as contaminated. I wrote them anyway. Little things. What the leaves looked like the week he was born. A joke his great-grandfather Walter used to tell about lawyers, which, given the family, felt almost cruel to include, but I included it every year regardless, because I wanted him to know that somewhere, someone thought he deserved a joke on his birthday, even if the rest of the day had been swallowed up by silence. And every year, from the trust my father had left in my care, I authorized a distribution. Small at first, school supplies, a summer camp deposit, things routed so carefully through a blind administrative structure that Richard's firm, for all its resources, for all its subpoenas and depositions and courtroom theatrics, never once traced the source. I had learned by then exactly how to build a wall that no one on the other side even knew was there. When Ethan turned 14 and the trust's terms allowed for educational disbursements, I quietly funded a summer academic program that changed the trajectory of his entire academic life, a program he later told an admissions committee, in an essay I read only because the program itself reprinted it in an alumni bulletin years afterward, had made him fall in love with the idea of law for the first time. Not as a family inheritance, but as a genuine calling. He thought a stranger had funded that opportunity. In a sense, to him, I was one. A stranger who happened to share his blood and had been kept so far from the rest of his growing up that by the time he finished high school, he could not have told you one true thing about me. I told myself, in the quiet moments when the loneliness threatened to swallow everything I had built, that this was still love. Different in shape than the love other grandmothers get to give, but love nonetheless. Love administered through a blind trust and an unsigned birthday letter, because it was the only kind of love the situation had left available to me. I did not know, for most of those 12 years, that the very firm my ex-husband had built his entire identity around was quietly rotting from the inside. I did not know it because I was not looking for it. I had made peace, or something close to peace, with never crossing paths with the Whitfields again. But peace, I have found, is rarely something you get to keep on your own terms. Sometimes it finds you anyway, delivered by an anonymous tip that lands, of all places, on your own desk. It came in the spring, 3 years before Ethan's graduation, in the form of a manila folder left with the disciplinary council's intake office, unsigned, containing photocopies of trust account statements from a firm I recognized the moment I saw the letterhead. Because I had spent 35 years of my life addressing envelopes with that exact same font. Whitfield and Associates, my former husband's firm, my former son's firm, because by then Daniel was managing partner, having taken over the practice from a father whose hands had begun to shake too much to sign his own name reliably. The documents showed a pattern any first-year law clerk could have spotted with training. Client trust funds commingled with the firm's general operating account, disbursements made against balances that should never have been touched, the exact kind of quiet, arrogant sloppiness that comes from decades of never once being questioned. I want to tell you exactly how that folder found its way to me, because for a long time afterward, I turned the coincidence over in my mind, unable to decide whether it was fate or simply the ordinary mechanics of a small legal community where paths cross more often than anyone expects. The Disciplinary Council's intake office shared a mailroom with the appellate chambers on the 3rd floor of the County Judicial Building, a detail that meant absolutely nothing to anyone until the Tuesday evening a temporary mail clerk, new to the building and unfamiliar with the difference between an intake folder and a chambers folder, dropped an unmarked manila envelope into the tray outside my office door instead of the intake office 2 floors below. I was working late that night, the way I often worked late in those years, because an empty apartment does not call you home the way a full one does, and a stack of appellate briefs was still a kinder companion than silence. I almost sent it back down unopened. I want you to understand that, because it would have been the easiest thing in the world to do. The correct procedural thing. The thing a careful judge does when a folder appears on her desk that was never meant to be there. I actually stood up from my chair, folder in hand, intending to walk it down to the intake office myself before the building locked for the night. But something about the weight of it, the particular density of paper that meant financial statements rather than correspondence, made me pause in the doorway of my own chambers. I told myself I was only checking to see which office it belonged to. I have never been entirely honest with myself about that moment, not even now. Some part of me, some old, wounded, watchful part that had spent 35 years learning to read the small print of other people's carelessness, already suspected what I would find before I opened the clasp. The letterhead stopped me cold in the doorway. Whitfield and Associates, printed in that same deep forest green ink the firm had used since the year Richard joined his father's practice. The same font I had chosen myself at 26 years old, standing in a print shop with swatches of paper fanned out across a counter, trying to make a young husband's name on an old firm's letterhead look as though it had always belonged there. I had picked that font. I had picked that shade of green. And 43 years later, I stood in a judicial mailroom holding evidence that the firm bearing my own long-ago choices had been quietly bleeding its clients dry for the better part of a decade. I sat back down at my desk that night and read the entire folder twice before I allowed myself to feel anything at all. That was a discipline I had built slowly, over years on the bench, the ability to separate the reading of facts from the reacting to facts. Because a judge who lets her stomach make decisions before her mind has finished gathering evidence is not a judge anyone should trust with someone else's future. The first page was a summary memorandum, unsigned, typed on a manual typewriter rather than a computer, which told me immediately that whoever had compiled it was being careful, deliberately avoiding any digital trail that might later be traced back to a specific machine or a specific printer in a specific office. Whoever had assembled this folder understood exactly how thoroughly a firm like Whitfield and Associates could weaponize discovery against a whistleblower, and had taken pains to leave nothing behind that could identify them. The second page was a photocopied account ledger, 3 client trust accounts listed side by side, with small red check marks beside 7 separate transactions that did not reconcile. The earliest discrepancy I found, working my way through those pages with a yellow legal pad at my elbow, was dated nearly 9 years earlier. A transfer of just under $60,000 out of an elderly client's trust account and into the firm's general operating account, reversed 11 days later with no explanation, no client authorization on file, and no interest credited for the 11 days the money had spent somewhere it was never supposed to be. $60,000. 11 days. No signature. I remember writing those 3 facts on my legal pad in block letters, underlining each one twice, because I had learned by then that the smallest, most precisely stated facts are always the ones that survive cross-examination. I did not sleep that night. I sat in my kitchen until nearly 4 in the morning with that folder spread across the table, running the same mental exercise I would have run for any disciplinary matter that crossed my desk in the ordinary course of my work, except that every single time I reached for professional distance, some small detail would drag me back into the personal. a client's last name that I recognized from a Christmas party 20 years earlier. A date that lined up almost precisely with a summer I remembered because it was the summer Daniel had been made partner, and Richard had rented out an entire restaurant to celebrate. I remember thinking, somewhere around 3 in the morning, how strange it was that a firm capable of celebrating its own children with that much extravagance had apparently, during that very same season, been quietly moving money that did not belong to it. By the time the sun came up, I had made 2 decisions, and I want to tell you both of them plainly, because I think they say more about who I had become than almost anything else in this story. The first decision was that I would not open a private investigation myself, would not use my position to quietly pull threads on my own, no matter how much some old, wounded part of me wanted the satisfaction of finding the answers with my own hands. I had spent the better part of a decade building a reputation for scrupulous fairness, and I was not willing to trade that reputation even for this. Even for the family that had once tried to convince an entire county I possessed no judgment worth trusting. The second decision was that I would not simply hand the folder to the intake office and walk away pretending I had never opened it. I had seen too much by then to unsee it, and a woman who had spent her whole life being told she lacked the fortitude to handle difficult things was not about to prove that assessment correct by looking away from $60,000 that had vanished from an old woman's trust account for 11 unexplained days. What I settled on, in the gray light of that morning, was something closer to stewardship than investigation. I brought the folder down to the intake office myself, first thing, before the building had properly woken up, and I handed it to the supervising clerk with a short written note explaining, honestly and completely, exactly how it had come to be on my desk instead of hers. I disclosed, in writing, my prior marriage to Richard Whitfield, my prior relationship to the firm named in the documents, and I formally recused myself, on paper, from any judicial role in whatever investigation might follow. I did this not because anyone had asked me to, and not because I expected anyone would ever check whether I had, but because I had promised myself, in a motel room outside Latimer County 12 years earlier, that I would never again allow myself to be the kind of person who managed inconvenient truths quietly, instead of naming them out loud. The supervising clerk, a careful, unflappable woman named Priscilla, who had worked in that office longer than I had been a judge, read my note twice, looked up at me over the top of her reading glasses, and said only, "This is going to take a while to work through properly, Judge Callahan. These things always do." I told her I understood. I did not tell her how long I had already been waiting for something like this, or how many years I had spent quietly, deliberately, refusing to let myself hope for it. The folder sat in the intake system for nearly 4 months before it was formally assigned to an investigator. 4 months during which I told no one, not even the few close friends I had made since rebuilding my life, that a matter involving my former family had crossed my desk and been sent, properly and correctly, into the machinery of an institution I trusted more than I had ever trusted the family itself. I want you to sit with that timeline for a moment, because it matters. 4 months of silence. 4 months of going about the ordinary business of being a judge, hearing unrelated cases, writing unrelated opinions, eating dinner alone in an apartment 2 hours from the house where I had once hosted holiday parties, all while knowing, quietly, that somewhere in that building, a case was slowly being built against people who shared my blood and had once told the entire county I was too fragile to be trusted with anything of consequence. I did not check on the file's progress. I did not use my position to ask quiet questions in hallways, the way I imagine Richard would have done without a second thought, because that was the entire point of what I had built in those 12 years. A life governed by rules I actually believed in, rather than rules that only applied to other people. I simply waited, the way I had learned to wait for so many other things. Birthday letters that might never be read, trust distributions that might never be traced back to their source, a grandson who might grow up never knowing my name. Waiting, I had discovered, was not the same thing as doing nothing. It was its own kind of discipline, quiet and exhausting and entirely invisible to anyone standing outside of it. I did not open that investigation myself. I want to be honest with you about that, because the story is more interesting and more true if I don't pretend to be some kind of avenging angel who engineered her own revenge from behind a judge's bench. The disciplinary counsel's office assigned the matter to a career investigator named Marcus Webb, a man I had mentored years earlier when he was fresh out of law school. Sharp, quiet, deeply allergic to unfairness in a way that made him excellent at his job and occasionally difficult company at dinner parties. Marcus came to my chambers on a Thursday afternoon with the file under his arm and an expression I had learned over years of working with him to recognize as trouble. "Judge Callahan," he said, closing the door behind him, "I think you're going to want to see this before I take it any further." He knew my history. Not all of it, but enough. Enough to know that the name on the letterhead in his hand was going to land somewhere very close to a wound he had never asked me to explain, and I had never volunteered to discuss. I read through that file twice before I said a single word. The trust account irregularities went back further than 3 years, further than 5. Further, if the earliest statements were accurate, than nearly a decade. Not enormous sums individually. A few $1,000s shifted here, a delayed disbursement there. The kind of pattern that survives for years precisely because no single instance is large enough to trigger an automatic audit. But cumulatively, across a decade, across dozens of client accounts, the number Marcus had calculated made my hands go cold around the edges of the folder. Nearly $2 million, unaccounted for, moved between accounts in ways that violated the most basic fiduciary rules I had spent the last several years of my professional life enforcing against far smaller offenders. I recognized some of the client names: elderly clients, small estates, people who had trusted Whitfield and Associates because the name on the door had 3 generations of local prestige behind it. People who had no earthly idea that a portion of their trust funds had been quietly used to smooth over the firm's cash flow problems during 2 separate recessions. I thought of Mrs. Kessler, our old neighbor, the one who had watched the process server hand me those divorce papers and pretended not to see. She had been a client of that firm for 30 years. I did not yet know, that afternoon, whether her name would appear in the final accounting, and the not knowing sat in my chest like a stone for the rest of the week. Here is where I want to be very precise with you, because precision matters in a story like this one, and I have no interest in making myself sound more powerful or more prophetic than I actually was. I recused myself from any judicial involvement in the matter that same afternoon. I could not, ethically, sit anywhere near a case involving my former husband's firm, and I told Marcus exactly that in exactly those words, and I meant every syllable of it. But recusal from the bench does not mean recusal from knowledge. I remained, quietly, a resource, a former insider who understood the firm's structure, its personalities, its particular blind spots, better than any outside investigator possibly could. I did not orchestrate the case against Whitfield and Associates. I simply, for the first time in 12 years, found myself standing very close to a fire I had not lit, watching it begin, slowly, deliberately, to catch. Marcus's investigation moved the way these things move, which is to say, agonizingly slowly, through subpoenas and forensic accountants and depositions that Daniel's firm fought at every possible turn, filing motion after motion, hiring outside counsel from 3 different states, behaving, in short, exactly like a family that had spent 3 generations believing the rules were things that happened to other people. I watched from a careful distance through Marcus, through the occasional court filing that crossed my desk in an entirely unrelated capacity, through the slow gathering of a case that I understood, in a way few outsiders could, was not simply a matter of professional misconduct. It was the exact same pattern of control and entitlement that had once been turned against me, now finally being turned back on the family that had wielded it, except this time, the evidence was documented, dated, and sitting in a government office instead of whispered around a dinner table. I did not tell Marcus, in those early months, about the personal history tangled up in that case file. I did not need to. He found out on his own, the way careful people always do, by noticing that I flinched, almost imperceptibly, whenever the name Whitfield came up in casual conversation, and by asking, gently, one evening over coffee in my chambers, whether I wanted him to keep me updated as things developed, or whether I would rather he simply let me know when it was over. I remember sitting with that question for a long moment before I answered. "Keep me updated," I told him. "I think I've earned the right to know." What I did not fully understand yet, sitting in my chambers with that folder in my hands, was that the timeline of Marcus's investigation was on a collision course with something else entirely. Something I had been quietly tracking for 12 years without ever letting myself think of it in those terms. My grandson Ethan, the boy of 12 I had last hugged goodbye before a process server rang our doorbell, had just started his first year of law school. The same law school, as it happened, in the same city where I now sat on the bench. And in less than 3 years, he would walk across a stage to receive a degree that, unknown to him, unknown to his parents, had been made possible in no small part by a woman they had spent 12 years describing to anyone who would listen as unstable, unwell, and unfit. I made a decision, in the spring before that ceremony, that I want to be honest with you was not entirely rational, not entirely strategic, not the calculated maneuver of a woman who had spent a decade learning to build airtight cases. It was, more simply, the decision of a grandmother who had written 12 birthday letters into a silence that never once answered back, and who had finally run out of patience for being a ghost in her own family's story. I decided I was going to attend that graduation, not as Eleanor Whitfield, the woman who had been erased, as Judge Eleanor Callahan, the woman I had built, brick by brick, out of the wreckage they left behind. Marcus, when I told him, looked at me for a long moment across his desk, the way he did whenever he was deciding whether to say something as my former mentee or something as an investigator who understood, better than most, how dangerous it can be to let personal history collide with an active case. "The investigation is going to go public within the year," he finally said. "The firm doesn't know it yet, but we're close to a formal disciplinary filing. If you're in that room, Eleanor, people are going to start connecting names." I told him I understood. I told him I had spent 12 years being invisible to that family, and I was not asking to disrupt his case. I was asking to see my grandson graduate, in the open, as myself, for the first time in more than a decade. Whatever came after that, I told him, I would let come. The months that followed moved in a strange double rhythm, one pace for the public record and an entirely different pace for the private one. And I found myself living inside both simultaneously, the way you sometimes live inside two rooms of the same house without ever quite closing the door between them. Marcus kept his word. Every few weeks, usually on a Thursday, usually over coffee that had gone lukewarm before either of us remembered to drink it, he would bring me the shape of things. Never names I shouldn't hear, never documents that crossed an ethical line, but enough for me to feel the case tightening the way a hand tightens slowly around a rope it has finally learned to hold with confidence. It was during one of those Thursday conversations that I first heard the name Kessler again, and I want to tell you honestly that hearing it nearly undid the careful composure I had spent a decade building. Marcus did not know, when he mentioned it, what that name meant to me. He was simply reading from a list of client accounts flagged for irregular activity, reciting them the way you recite any list, methodically, without weight, and somewhere in the middle of that list, between a corporate escrow account and a small estate trust, he said, Kessler, Dorothy, 81 years old, widow, account opened in 1994. I set my coffee cup down very carefully on his desk, because my hands had begun to shake in a way I did not want him to see. Dorothy Kessler had been our neighbor for 11 years. She was the woman who had stood on her porch with her small terrier on a leash, pretending very hard not to watch, the morning a process server handed me divorce papers in front of my own front door. I had always wondered, in the years since, whether her studied indifference that morning had been kindness or cowardice, whether she had looked away because she could not bear to witness my humiliation, or because she had already decided, along with everyone else in that neighborhood, which side of the story deserved her loyalty. Learning that her trust account, the modest nest egg her late husband had spent 30 years as a postal supervisor building for her, had been quietly drained and refilled 11 separate times over 9 years, told me something I had not fully let myself understand until that moment. Whatever Dorothy Kessler had believed about me back then, she had trusted the Whitfield name completely, the same way I once had, and that trust had cost her more than either of us could have guessed on that cold February morning. I want to tell you a memory about Dorothy Kessler that I had not let myself think about in years, because it surfaced, unbidden and complete, the moment Marcus said her name across that desk. It was a Tuesday afternoon, sometime in the second decade of my marriage, and I had been standing at my own mailbox in a light rain, sorting through catalogs I had no intention of reading, when Dorothy crossed her lawn in a plastic rain bonnet, holding a covered dish, because her tomatoes had come in heavier that year than she and her husband could possibly eat alone. She had pressed that dish into my hands, still warm, and said in the plain, unhurried way she said most things, "You work too hard making everyone else comfortable in that house, Eleanor. Somebody ought to feed you for once." And then she said the thing I have carried with me every single day since, in the same plain voice she used for talking about the weather. "Being needed is not the same as being loved, honey. That house needs you. Don't you ever let it teach you those are the same word." I remember standing in the rain, holding a casserole dish of stewed tomatoes, feeling more genuinely seen in that 30-second exchange than I had felt in months inside my own home. I never told her that. I do not think I ever told anyone that, until now. That memory, more than any account statement, was the thing that made me understand exactly what had been stolen from her, and from people like her, over the 9 years those trust records covered. Not simply money, though the money mattered enormously, especially to a woman living on a postal supervisor's modest pension. What had been stolen was the quiet, ordinary faith she had placed in an institution because the institution wore a name she trusted. Because trust, for people of Dorothy's generation, had always been a currency you spent freely on the people who seemed to have earned it, and rarely thought to audit afterward. I want to be honest with you about the temptation I felt, sitting in Marcus's office that afternoon, to simply pick up the phone and call Dorothy myself, to warn her, to explain, to somehow soften whatever was coming before an official notification letter landed cold and impersonal in her mailbox. I sat with that temptation for the better part of an hour after Marcus left, turning it over the way I had learned to turn over every impulse before acting on it. And in the end, I did not call her. I want you to understand exactly why, because I think it says something important about the woman I had become in those 12 years. If I had called Dorothy Kessler directly, I would have been doing exactly what the Whitfields had always done best, using a private relationship to shape the outcome of a matter that belonged, by every rule of ethics I had spent a decade enforcing against far smaller offenses, to a formal process designed to protect people like her from exactly that kind of quiet, well-intentioned interference. I had spent my career punishing attorneys for believing their personal judgment outweighed proper procedure. I was not about to become, even out of love, even out of guilt, the kind of person who excused herself from her own rules the moment they became inconvenient. So I did the harder thing instead. I waited, and I let the system I had helped build move at its own careful pace, and I trusted, the way I had learned to trust very few things in my life, that doing this correctly would ultimately serve Dorothy better than doing it quickly. It was not the only name on that list that kept me awake in those weeks. Marcus mentioned others in the months that followed, carefully, in the general shape he was permitted to share. And I want to tell you about at least one more, because I think the scale of what had happened deserves to be understood beyond a single sympathetic neighbor. There was a small family trust, established for a disabled adult son whose parents had both passed within 18 months of each other, leaving him a modest but carefully structured fund meant to supplement his care for the rest of his life. Marcus told me, without naming him directly, that nearly $11,000 had been quietly diverted from that account over a 4-year period, transactions disguised as administrative fees that exceeded, by a considerable margin, anything the firm's own published fee schedule allowed. I remember sitting with that particular detail longer than almost any other, because it represented something even more indefensible than Dorothy's story. Dorothy, at least, had other resources: a modest pension, a paid-off house, a support system of neighbors, and a niece 2 states away who checked in every Sunday. This young man had almost nothing else standing between him and genuine hardship, and the firm that was supposed to safeguard his one remaining protection had treated his account, like all the others, as a quiet, renewable source of short-term liquidity whenever the partner's spending outpaced their billing. I found myself, during those months, doing something I had not expected. I began keeping a private list of my own, not of account numbers or dollar figures, information I had no ethical right to possess in that kind of detail, but simply of names, first names only, the ones Marcus occasionally mentioned in passing before catching himself and redirecting the conversation back toward general patterns rather than specific people. Dorothy, the young man whose parents had tried so carefully to protect him, a retired schoolteacher, a church committee's modest building fund. I kept that list folded inside my desk drawer, not as evidence, not as anything resembling a case file, but simply as a private reminder, on the difficult days, of exactly why the discipline of waiting mattered as much as it did. Every one of those names represented a person who deserved, eventually, to know the truth, and every one of them deserved to receive that truth through a process careful enough to withstand every challenge the firm's expensive outside counsel could throw at it. I thought often, during that stretch of quiet waiting, about my father, about the particular kind of patience that had allowed him to structure a trust so precisely that it could keep its true shape hidden for 14 years before it finally opened. I understood, more completely with each passing month, that he had given me more than money when he built that trust. He had given me a model for exactly this kind of restraint, the willingness to let something correct and true take however long it actually needed, rather than reaching for a faster, messier version of justice that might feel satisfying in the moment, but would ultimately fail the very people it was meant to protect. I will admit to you that there were nights during those months when the waiting felt unbearable, when I sat alone in my apartment turning Dorothy Kessler's name over in my mind and wondering whether some part of what had happened to her was, in some small twisted way, connected to me, to the family I had once been part of, to the 35 years I had spent smoothing every rough edge in that household, instead of asking harder questions about where the money actually came from and where it actually went. I want to be honest that this thought visited me more than once, and it took real effort, real discipline, to remind myself that I had not been the one moving money between accounts, that I had, in fact, been systematically excluded from every financial decision of consequence precisely because Richard had never trusted me with real authority over anything that mattered. The guilt I felt was, I came to understand, simply another echo of the same old lie, that I was somehow responsible for things I had never been permitted to control. I mentioned some of this, carefully, to Marcus during one of our Thursday conversations. Not the specific guilt, which felt too private even for him, but the general weight of watching a case unfold that touched people I had once considered neighbors, almost friends, in a life I had left so far behind that it sometimes felt like it belonged to someone else entirely. He listened the way he always listened, without interrupting, and when I finished, he said something I have carried with me since. "You're allowed to grieve what happened to them, Eleanor, without taking responsibility for it. Those aren't the same thing, even though they can feel identical at 2 a.m. I told him he was right. I did not fully believe it yet, not that night, but I told him he was right, because some truths need to be spoken aloud several times before the body finally agrees to accept what the mind has already understood. I asked Marcus, carefully, whether Dorothy had been informed yet that her account was under review, and he told me the notification letters were scheduled to go out within the month, a standard part of the disciplinary process, formal, neutral, entirely correct. I did not ask him to move faster. I did not ask him to move slower. I simply sat with the knowledge that a woman who had once watched my whole life collapse from a safe distance was about to discover that the very institution she had trusted more than she had ever trusted me was the one that had quietly failed her. I want to tell you about another Thursday, several weeks later, because it changed the shape of everything that came after it. Marcus arrived at my chambers that afternoon with a different kind of expression on his face. Not the careful neutrality he usually wore when discussing the case, but something closer to genuine unease. "We took Daniel's deposition yesterday," he said, sitting down across from me without his usual preamble. "I need to tell you something, and I need you to hear it as a person before you hear it as anything else." What he told me was this. Daniel, under oath, questioned about a specific transfer from an elderly client's account in the year Richard's health had first begun visibly declining, had testified that his father had personally authorized the transfer, verbally, without documentation, because the firm's cash flow that quarter had been, in Daniel's words, temporarily strained. He had said it, Marcus told me, without any apparent understanding of how damning the admission actually was, the casual confidence of a man who had spent his entire adult life believing that explanations offered in his own voice were automatically accepted as sufficient. He had not lied, exactly. He had simply told the truth, as though the truth could not possibly be a problem, because, in his experience, up until that room, it never had been. I sat with that story for a long time after Marcus left that evening. turning it over the way I once turned over Richard's sentence in that study, the one that told me I was never fit to be a Whitfield. There was a symmetry to it that felt almost unbearable. Richard had spent our entire marriage insisting that his judgment alone was sufficient authority, that questions were an insult rather than a safeguard, and he had passed that same conviction down to his son so completely that Daniel had walked into a deposition and handed the state, without a moment's hesitation, exactly the admission it needed. I want to jump ahead of myself for a moment here, because this belongs beside that deposition more than it belongs anywhere else in the telling. Months after that Thursday, once Ethan and I had finally begun speaking, and I will tell you shortly exactly how that came about, I came to look forward to the sound of his voice on a Sunday evening the way I imagine other grandmothers look forward to visits I had never been allowed to have. We developed, in those few short weeks, a quiet rhythm of our own. He would tell me about a professor he admired, or a moot court argument that had gone badly, or a girl in his contracts class he was too nervous to ask to coffee. And I would tell him, carefully, selectively, about the version of my own life I felt ready to share, leaving out the parts that were not yet mine to give him. It was during one of those calls, in the last week before the ceremony, that he told me something that has stayed with me ever since. He mentioned, almost in passing, that he still had a shoebox of birthday cards somewhere in his childhood bedroom, cards from someone he'd never been able to identify, signed only with a small drawing of an oak leaf in the corner, because I had always drawn one, every single year, without ever writing my name beneath it, a habit born less of caution than of a heartbreak I could not fully explain even to myself. I used to think about that leaf a lot, he told me. I used to wonder who cared enough to send something every year and never ask for anything back. I did not tell him, that evening, that the leaf had been mine. I was not ready yet, and neither, I suspected, was he. But I hung up the phone that night and sat alone in my kitchen for a long time, understanding, more clearly than I had in years, exactly how much of myself I had managed to plant in soil I could not see, waiting, patiently, for a season I had almost stopped believing would ever arrive. There was a moment, I will admit to you now, when my resolve nearly broke entirely, and I think it is important to tell you about it, because I do not want you to believe this story belonged to a woman who never doubted herself. It happened on a rainy Tuesday in late autumn, when Marcus called to tell me that outside counsel for Whitfield and Associates had filed a motion attempting to have the entire disciplinary investigation dismissed on procedural grounds, arguing, among other things, that the anonymous nature of the original tip rendered the whole inquiry fundamentally unreliable. For 3 days, I did not know whether that motion would succeed, whether everything that had been quietly building towards some kind of reckoning would simply be dismantled by a well-paid attorney's clever footnote, the way so many things in that family had always been dismantled, not through honesty, but through procedure wielded as a weapon. I remember standing at my kitchen window during those 3 days, watching rain slide down the glass, and feeling, for the first time in over a decade, the old fear creeping back in. The fear that no matter how much I rebuilt, no matter how far I climbed, the Whitfield name would always find a way to outmaneuver whatever justice I thought I had finally earned. I did not call Marcus during those 3 days to ask for updates. I did not pace or panic or reach for the phone the way the old version of me might have. I sat with the fear instead, let it move through me completely, and reminded myself, quietly, that I had already survived losing everything once, and had built an entire second life out of the wreckage. Whatever happened with that motion, I told myself, I was not the same woman who had once stood on a porch with 2 suitcases and nowhere to go. The motion was denied on a Friday afternoon in a 12-page written opinion from a judge I had never met, who found, in language I read 3 times just to be certain I hadn't imagined it, that the pattern and consistency of the underlying financial records rendered the anonymous origin of the original tip entirely immaterial to the investigation's validity. I read that opinion standing in my own kitchen, the same window where I had stood 3 days earlier watching the rain, and I felt something loosen in my chest that had been clenched, I realized, for longer than just those 3 days. Longer, perhaps, than the entire 12 years. It was after that denial, sitting alone that evening with the opinion printed and spread across my kitchen table, that I finally allowed myself to fully commit to the plan that had been forming, quietly, in the back of my mind since the day I first learned Ethan's graduation date. I was going to attend that ceremony, not as a fallback, not as a hope, but as a certainty, and whatever collided in that single afternoon, the case, the family, the 12 years of silence, I was finally, completely ready to let it collide. There was one more thing I needed to settle before that day arrived, and it required a visit I had been putting off for years, not out of fear exactly, but out of something closer to grief. I needed to see Walter Callahan's original trust documents one final time, to confirm the exact terms of the disbursement structure that would activate automatically the moment Ethan turned 25, an age he would reach in a little over a year. My father, it turned out, had built something even more precise than I remembered. The trust did not simply provide for Ethan's education. It named him, upon reaching 25, sole beneficiary of a controlling minority stake my father had quietly purchased decades earlier in the commercial building that housed, of all things, Whitfield and Associates' downtown offices. A building the firm had leased for 30 years without ever once realizing that the ultimate ownership structure ran, eventually, straight back to a Callahan. I want to sit with that detail for a moment, because when I first rediscovered it in the trust paperwork, I laughed out loud, alone in my study, an ugly, disbelieving laugh, because it meant that for 12 years, the family who called me unfit to be a Whitfield had been paying rent, however indirectly, however many corporate layers removed, into a structure that would one day belong entirely to the grandson they had used against me. My father had not been sentimental when he built that trust. He had been surgical. And in that surgical precision, I finally understood the full shape of the inheritance he had left me. Not just money, not just a title deed. A patience so complete it could wait for a boy to turn 25 before it closed its hand. I spent the following months doing the quiet, unglamorous work that any real reckoning always requires. The work no one applauds because it happens in file folders and phone calls instead of courtrooms and confrontations. I met twice with the trust's administering attorney to confirm the disbursement timeline could not be challenged or delayed. I reviewed, with Marcus's careful permission and under strict confidentiality, the general shape of the disciplinary case's public timeline, enough to know, roughly, when a filing might become a matter of public record, without ever crossing the line into anything that could compromise his investigation. I bought a single new outfit for the graduation, a tailored charcoal suit, simple, unadorned, the opposite of everything the Whitfields had ever worn to signal their status, because I had learned, over 12 years, that the quietest fabric in the room is often the one doing the most talking. I also did the one thing that made those Sunday telephone calls possible in the first place, something I had never done before in all those years of silence. I wrote to Ethan directly, not as an anonymous birthday well-wisher, but as myself, using the return address of my chambers, on paper with the state seal printed discreetly in the corner. I did not explain everything. I simply told him that I was, and had always been, his grandmother, that I would be honored to attend his graduation if he would permit it, and that whatever he decided, I understood, and I loved him regardless. I did not know, mailing that letter, whether it would reach him any more successfully than the 12 birthday letters that came before it. I only knew that I could not walk into that graduation as a stranger to the one person in that family whose forgiveness I actually wanted. The reply came 4 days later, not by mail, but by phone. A number I did not recognize calling my chambers directly during office hours, and when I picked up, a young man's voice, cautious and a little breathless, said, Is this Judge Callahan? This is Ethan Whitfield." I had to sit down. 12 years of silence, and the first sound I heard from my grandson as an adult was him introducing himself to me formally, politely, the way you introduce yourself to someone you are not yet sure you are allowed to know. We spoke for nearly an hour that day, carefully, gently, both of us picking our way across territory neither of us fully understood. He told me about the summer academic program that had changed his life at 14, the one he still believed had been funded by an anonymous scholarship board. I did not correct him. Not yet. I told him only that I would very much like to be at his graduation, quietly, without disrupting anything for his family, and that the decision of how much to tell his parents beforehand was entirely his to make. He was quiet for a long moment on the other end of the line, and then he said something that I have turned over in my mind many times since. "I barely remember you," he said. "They made very sure of that, but I remember missing something. My whole life, I think I've been missing something, and nobody would ever tell me what it was." I told him I was sorry it had taken this long. He told me not to be sorry. He told me to just come. He did not tell his parents. That was his choice, made carefully, with a maturity that startled me given how young he still was in so many other ways. And when I asked him why, over a second phone call 2 weeks before the ceremony, his answer told me everything I needed to know about the family that had raised him. "Because if I tell my dad you're coming," he said, "he'll find a way to make it about him before it even happens. I want one day, just one, that's actually about me. I'll introduce you when it's the right moment, I promise." I agreed to his terms completely. I had waited 12 years. I could wait for the right moment inside a single afternoon. What none of us knew yet, not me, not Ethan, not Marcus quietly finalizing his case file 2 counties away, was that the timeline I had spent months carefully managing was about to collapse into a single day. Because 3 days before the graduation, Marcus called me with news that changed everything. The state bar's disciplinary board had voted, unanimously, to authorize a formal public filing against Whitfield and Associates, effective immediately, with the official notice scheduled to be delivered to the firm's managing partner, Daniel Whitfield, the following Monday. The graduation was on Saturday. For the first time in 12 years of careful patience, the pieces I had spent a lifetime assembling were about to arrive in the same room, on the same afternoon, without my having planned a single second of the collision. My grandson's graduation. My reintroduction to a family that no longer recognized my face. And a legal reckoning I had watched build for 3 years, about to detonate less than 72 hours after that afternoon ended. I remember standing in my kitchen the night before, holding that charcoal suit on its hanger, and thinking that my father, wherever he was, had probably known exactly what kind of precision this moment would require, and had simply trusted me to be ready for it when it came. I want to walk you through that Saturday morning slowly, because I have relived it so many times since that I could describe the exact angle of the light coming through the chapel's stained glass windows, the particular smell of fresh-cut grass mixed with someone's over-applied perfume, the sound of a brass ensemble tuning up somewhere behind the stage. I arrived early, before the family section filled in, and found a seat near the back, close enough to see, far enough to remain unnoticed, which, I had learned by then, was a very particular skill for a woman who had once made an entire career out of blending into rooms she was never meant to command. Ethan found me before the ceremony began. He slipped away from the graduate lineup for exactly 90 seconds, still in his cap and gown, his face flushed with the particular nervous joy of a young man about to become official. And he hugged me so hard and so suddenly that I nearly lost my balance on the grass. "You came," he whispered into my shoulder, and I felt 12 years of silence crack open in my chest all at once. "Of course I came," I told him. "I never stopped coming, Ethan. You just couldn't see me yet." He had to go back before anyone noticed his absence, and I watched him jog back toward the lineup of black gowns and gold tassels, disappearing into a crowd of 200 graduates who all, for one glorious, ordinary moment, looked exactly the same. I did not see the rest of my family until the ceremony ended, until the degrees had been conferred and the caps thrown, and the crowd began its slow migration toward the reception on the chapel lawn, where round tables draped in white linen waited under a striped tent, and champagne flutes caught the afternoon light like small captured stars. I saw Richard first, from a distance, and I want to tell you honestly that the sight of him did not undo me the way I had once feared it might. He had aged the way men age when they've spent their lives being obeyed rather than questioned. Thinner, grayer, a slight stoop to shoulders that used to carry themselves like a verdict. He was in a wheelchair, pushed by an aide I did not recognize, and something in his face, even from 30 feet away, looked diminished in a way that had nothing to do with age. I felt, watching him, not triumph, but something closer to sorrow for the version of him that might have existed if he had ever once, in 35 years of marriage, chosen curiosity over control. I watched his aide adjust a light blanket over his knees despite the warm afternoon. The kind of small, practiced gesture that only develops between people who have spent months learning the particular needs of a body that no longer manages itself the way it once did. And I found myself wondering, distantly, what illness or combination of illnesses had brought Richard Whitfield, of all men, to this point. He had always been so proud of his physical bearing, the straight shoulders, the deliberate stride across a courtroom, the way he used to enter a room already certain of where the power in it would eventually settle. Watching a stranger tuck a blanket around his knees felt, in some complicated way I did not fully expect, less like justice arriving and more like watching a building I once lived inside slowly lose its foundation, board by board, over years I had not been present to witness. I let myself remember, for just a moment, the Richard I had married, because I think it is important, even now, even after everything, to tell that part honestly rather than simply painting him as a villain from the very beginning. He had been magnetic once, genuinely so, the kind of young attorney who could walk into a room of skeptical senior partners and leave them nodding within 20 minutes. And in the earliest years of our marriage, before ambition had fully hardened into something colder, he had been, in his own limited way, tender toward me. I remembered a spring evening early in our marriage when he had driven 45 minutes out of his way after a late deposition simply to bring me soup from the one restaurant I had mentioned, offhand, that I missed from childhood. I remembered him sitting beside my hospital bed after Daniel was born, holding my hand so tightly I had to ask him to loosen his grip, tears standing in his eyes in a way I never once saw again in all the years that followed. I do not tell you this to excuse what came later. I tell you this because I think the truth of a marriage like ours is rarely a single clean line from love to cruelty. It is, instead, a slow accumulation of small surrenders, each one so minor in isolation that you barely notice you have made it, until one day you look up and realize the person standing across from you has quietly rearranged the entire architecture of your life without your ever formally agreeing to any of it. Richard did not become controlling overnight. He became controlling one small decision at a time, one dismissed opinion at a time, one moment where I chose peace over confrontation, because confrontation, in that house, always cost more than it seemed worth. By the time my father's trust forced the real test of who Richard actually was underneath the charm, I had spent 3 decades training myself not to notice the weight settling onto my own shoulders. Watching him now, diminished in that wheelchair, I felt something far more complicated than triumph. I felt, if I am honest with you, a kind of grief for both of us, for the young couple who had once genuinely believed they were building something permanent together, and for the 2 very different people we had each, in our own ways, been forced to become by the choices Richard made when real power, real testing, finally arrived at our door. I did not walk toward him. I did not feel any pull to offer comfort or forgiveness or even simple conversation. Not yet. Not on that lawn, with everything still ahead of us that afternoon. I simply stood at the edge of the tent and let myself feel the full complexity of what I was looking at. A man who had once loved me clumsily and imperfectly, and who had then spent 12 years telling an entire county that I had never been fit to stand beside him at all. I want to tell you something else about that moment, something small that I have never told anyone else, because it felt too strange, too private to say aloud until now. As I watched Richard's aide settle his blanket, I found myself, unbidden, mouthing a single word under my breath, a word I had not spoken in 12 years. His first name, the way I used to say it in the earliest years of our marriage, before it became a word I associated primarily with dread. Richard. Just his name, quiet, almost tender. A small, private farewell to whatever remained of the man I had once genuinely believed I would grow old beside. I do not know if he would have understood, if he had somehow heard me, that the tenderness in that single whispered syllable was real, and that it existed entirely separately from everything that was about to happen to him and his firm in the days ahead. Grief and justice, I had learned by then, were not opposites. They could occupy the exact same breath. I let that moment pass, the way I had learned to let so many moments pass over the previous 12 years, fully felt and then quietly set aside. Because dwelling too long in any single emotion, even a true one, was a luxury I had rarely been able to afford. I straightened my shoulders inside that tailored charcoal suit, adjusted the small clutch under my arm, and let my gaze move on from Richard, scanning the rest of the gathering crowd near the reception line, searching, almost against my will, for the 2 other faces I knew would eventually complete the picture. I found Vanessa before I found Daniel, which did not surprise me even slightly, because Vanessa had always had a particular gift for positioning herself exactly where the most important conversation in any room was likely to happen next. A skill I imagine had served her well in her own career, and had certainly served her well over the years in staying close to whatever version of family approval was currently in fashion. She stood near the head of the reception line in a fitted ivory suit, sharp at every seam, her dark hair pulled back in the kind of severe, elegant knot that photographs beautifully and says, without a single word, that its wearer has no patience for anything approaching softness. Vanessa I recognized instantly. 44 now, sharp-suited, standing near the reception line with the particular posture of a woman who had spent her entire career being the most competent person in every room and needing everyone to notice it. And beside her, Daniel, managing partner, 46 years old, gray threading through hair that used to be jet black, holding a champagne flute with the easy confidence of a man who had never once, in his entire adult life, had a room fail to rearrange itself around him. I watched him laugh at something a colleague said, that same laugh I remembered from childhood. And for one disorienting moment, I was not a judge, not a trustee, not a woman who had rebuilt herself from nothing. I was simply a mother, watching her son from a distance he did not know existed. I want to describe that reception lawn to you fully, because I think the setting matters as much as anything that happened on it. The tent itself stretched nearly the length of a tennis court, striped canvas in cream and forest green. The same forest green, I noted with a small private irony, that had once decorated the letterhead sitting in a manila folder on my desk. Round tables draped in white linen circled a small dance floor no one was using yet, and somewhere near the back, a string quartet the university had hired played something quiet and forgettable, the kind of music meant to fill silence without demanding anyone actually listen to it. I stood near the edge of that tent for what felt like a very long time, though my watch told me it had only been 11 minutes, watching 200 families do the ordinary, beautiful work of celebrating their children. A father in a rumpled blazer wept openly, while his daughter, still in her cap, laughed and swatted his shoulder with her rolled diploma. A grandmother in a wheelchair held both hands up toward a young man kneeling in the grass beside her, cupping his face the way you cup something precious and slightly unbelievable. I watched all of it with the particular ache of a woman who understood, more completely than almost anyone else standing on that lawn, exactly how much ordinary tenderness could be taken from a family in the space of a single afternoon, and exactly how long it could take to earn even a fraction of it back. My phone vibrated once in the small clutch I carried, and I felt it against my palm before I even opened the clasp. A text from Marcus, sent, I would learn later, from his own daughter's soccer game 2 counties away, because even on a Saturday, even off the clock, he had apparently been thinking about the timeline as closely as I had. The message was short. Filing goes to the printer Monday at 8. Once it's filed, it's public record by noon. Thinking of you today. However it goes, you earned this. I read it twice, standing there in the dappled shade at the edge of that tent, and I felt the full weight of what was about to happen settle over me like a second layer of fabric beneath the charcoal suit. 2 days. 2 days between this ordinary, golden afternoon and the moment an entire county would open its newspaper and read, in black and white, exactly what Whitfield and Associates had spent a decade quietly doing to people like Dorothy Kessler. I slipped the phone back into my clutch and closed the clasp, and it was in that same moment that an older woman standing near me, silver-haired, in a lavender dress with a corsage pinned slightly crooked at her shoulder, turned and offered me the easy, instinctive warmth that strangers extend to one another at events built entirely around pride. "Isn't it something?" she said, gesturing toward the crowd of black gowns still scattered across the lawn. "Watching them all grown up like this? I keep looking for the little boy who used to hide under my kitchen table, and instead I've got a grandson with a law degree." She laughed, a little damp-eyed, the way people laugh when joy and disbelief arrive in the same breath. "Who are you here for, dear?" It was such a simple question, the kind asked 100 times an hour at any graduation reception in the country, and it very nearly undid me entirely. Who are you here for? I had spent 12 years being unable to answer that question honestly to anyone, because the true answer, my grandson, had been legally and emotionally unavailable to me for so long that I had almost forgotten what it felt like to say it plainly, without qualification, without bracing myself for the follow-up question that usually came next. My grandson, I told her, and I felt the words leave my mouth with a kind of trembling relief, the sentence itself feeling foreign and enormous, the way a phrase feels the first time you say it aloud after years of only thinking it. Ethan, he's just over there, by the photography setup. Oh, he's a handsome one, she said warmly, following my gaze across the lawn to where Ethan stood, cap tucked under one arm, laughing at something a friend had said, his gown still slightly askew from the ceremony. You must be so proud. I told her I was, and I meant it, more completely than she could have possibly understood. Standing there in her lavender dress with her crooked corsage, having no idea that the woman beside her had spent 12 years writing birthday letters into a silence that never answered. 12 years authorizing quiet trust disbursements a family of lawyers had never once managed to trace. She smiled at me once more, the easy smile of someone whose day held no hidden reckonings, and drifted back toward her own family's cluster of chairs, leaving me alone again at the edge of the tent with my clutch, my 2-day countdown, and my resolve. I watched Ethan a while longer before I made myself move. He had always had, even as a very small boy, the particular gift of making other people feel at ease around him, a warmth that I suspect he had not inherited from either of his parents, but had built, quietly, out of his own instincts, the same way I had once built an entire second life out of nothing but a trust document and a stubborn refusal to disappear. I watched him introduce a classmate to a professor with genuine enthusiasm, watched him laugh at his own joke before anyone else had a chance to, watched him glance, every so often, toward the edge of the crowd where he knew I was standing, a small private check-in, as though he needed to confirm every few minutes that I hadn't slipped away again, the way people from his childhood apparently had a habit of doing. I thought, standing there, about my father, about the particular kind of patience that had allowed him to build a trust structure so precise it could wait for a boy to turn 25 before it revealed its full shape. And I understood, finally, standing on that lawn in my tailored charcoal suit, that I had inherited more from him than a trust document and a stubborn last name. I had inherited his willingness to wait exactly as long as a thing required, without ever once mistaking patience for surrender. 12 years of birthday letters. 3 years of watching a case build itself slowly toward the truth. 2 more days until that truth became impossible for anyone to ignore. I had waited through all of it, and I was not about to lose my nerve now, standing 30 feet from the family that had once told an entire county I lacked the fortitude to be trusted with anything at all. I noticed, glancing toward the reception line, that Richard's aide had wheeled him into a patch of shade near the head table, and that Vanessa had drifted away from her father to join a small cluster of former classmates, laughing too loudly at something, the particular performance of a woman who needed every room to register how well she was doing. Daniel remained near the center of it all, champagne flute in hand, holding court the way he always had, the way his father had before him, the way, I imagine, some version of his own son might one day have learned to do, had Ethan not somehow, against every likelihood the family's example presented, grown into someone entirely different. I want to tell you honestly that some part of me, Standing there, watching my former family move through that golden afternoon in complete oblivion, felt a flicker of something close to grief for the version of this day that might have existed in some other life. A version where I had never been called unfit, never been handed divorce papers on my own front porch, never spent 12 years writing letters into a silence that swallowed them whole. In that other life, I would have been standing at Daniel's side right now, not at the edge of a tent, calculating exactly when to cross 30 feet of grass toward a family that no longer recognized my face. But I did not live in that other life, and grieving for it, I had learned over 12 long years, only ever cost me time I could have spent building something real out of the life I actually had. I looked once more toward Ethan, who caught my eye across the lawn and offered a small, private nod. The kind of nod that meant, without words, that whenever I was ready, he was ready too. I thought of Marcus's text still glowing somewhere in my clutch, of the 2 days left before the truth became public record, of Dorothy Kessler's account statements sitting in an intake folder 2 counties away, of 12 birthday letters and a shoebox with an unsigned oak leaf drawn faithfully in the corner of every single one. I thought of my father and the years of patience he had built into a single trust document, and I understood, standing there with the late afternoon sun warming the back of my neck, that I had run entirely out of reasons to wait even one moment longer. I made my way toward the reception line slowly, deliberately, my charcoal suit moving through a crowd of families in pale summer dresses and blue blazers. And I want you to understand that I was not there to make a scene. I was there to stand near my grandson on the day he had earned, to let him introduce me when he was ready, exactly as we had agreed. I did not anticipate what happened next, though perhaps, looking back, I should have. 12 years does not change certain instincts. It only sharpens the discomfort they cause when they resurface. It was Daniel who saw me first, standing slightly apart from the reception line, watching for Ethan. And something in my posture, or my proximity, or simply the fact that I was a woman he did not recognize standing closer to his family circle than he felt comfortable with, triggered exactly the response 35 years of marriage had trained me to predict. He crossed the lawn toward me with the particular brisk efficiency of a managing partner handling an unwanted solicitor. And he said, in a voice pitched for politeness, but carrying an unmistakable edge of dismissal, "Ma'am, I think you have the wrong event. This is a private family celebration. I'm going to need you to step back from the reception line." And there it is, the moment I opened this story with. My own son, 3 feet away, looking directly into the face of the woman who had carried him, raised him, sat up with him through every childhood fever, and seeing nothing there but an inconvenience to be managed. I did not raise my voice. I have told you already that I never did, not even now, not even with the weight of everything I had built pressing quietly against the back of my teeth. I simply looked at him, and I let the silence stretch 1 beat longer than was comfortable, because I had learned on the bench that silence is sometimes the most precise instrument available to you. "I have the right event, Daniel," I said. "I have always had the right event. You're the one who's confused about who's standing in front of you." I watched the recognition arrive in pieces, the way a verdict sometimes arrives on a jury's face before the foreperson has even finished reading it aloud. First, confusion. a small furrow between his brows at the sound of his own name in a stranger's mouth. Then something flickering, uncertain, at the shape of my jaw, or the particular way I held my shoulders. Some muscle memory buried so deep in the childhood he had spent inside my house that it survived even his own determined forgetting. And then, finally, the color left his face entirely, all at once, the way it does when the ground beneath a person turns out not to be ground at all. "Mom?" The word came out of him small, cracked, nothing at all like the confident voice that had told me 90 seconds earlier to step back from the reception line. Around us, I became aware of the particular quality of attention a small crowd generates when it senses, without yet understanding, that something significant is unfolding. Vanessa turned first, her champagne flute frozen halfway to her lips. Richard's aide wheeled him closer, drawn by his daughter's sudden stillness. And Ethan, cap still in hand, saw me standing in the center of his family's stunned silence and understood, in an instant, exactly what he had promised to wait for, had just arrived well ahead of schedule and considerably louder than either of us had planned. I want to pause here, because I know how this looks from the outside. It looks like the moment of triumph, the scene every part of this story has been building toward, and in some ways, it was. But I remember, standing there on that lawn, feeling something far more complicated than victory. I felt 12 years of grief arrive all at once, undiluted, because the boy who had hugged me on the grass an hour earlier had grown into a man who had spent his entire childhood believing his grandmother was simply gone, and the family standing frozen in front of me had spent that same childhood teaching him exactly why. "It's Eleanor," I said quietly, to the small, stunned crowd that had gathered without quite meaning to. Or Judge Callahan, if that's easier for everyone here to process. I watched Daniel's mouth open and close twice without producing a sound, and I understood, watching him, that I had just handed him, without raising my voice even once, the single most disorienting moment of his adult life. Vanessa recovered first, the way she always had, sharp and quick, where Daniel was slow and stunned. "Judge?" she repeated, and I heard, underneath the confusion, the beginning of calculation, the particular sound of a lawyer's mind reaching for footing on ground that had just shifted beneath her. "Judge Callahan? That can't be. You left. Dad said you were—" She stopped herself before the word landed, but I had spent 12 years anticipating exactly which word she would reach for, and I finished the sentence for her, evenly, without a trace of the old wound in my voice. "Unfit," I said. "Your father told you I was unfit. Unstable. Not fit to be a Whitfield. I remember the phrasing precisely, Vanessa, because your father said almost exactly that same sentence to my face, in his study, on a Tuesday evening 12 years ago, 4 months before he had a process server hand me divorce papers on our own front porch." The crowd around us had grown, quietly, the way crowds do at events like this, drawn by proximity and unresolved tension rather than any clear understanding of what was unfolding, and I was aware, distantly, that whatever was happening now was happening in front of witnesses none of us had chosen, but none of us could uninvite. Richard, from his wheelchair, made a sound low in his throat that might once have been the beginning of a courtroom objection, decades of instinct reaching for a rebuttal his body could no longer fully deliver. "Eleanor," he said, and his voice, once so precise, so controlled, wavered on the second syllable of my own name. "You shouldn't be here. This is Ethan's day." "It is Ethan's day," I agreed, "which is exactly why I'm here, Richard. He invited me himself, 3 weeks ago, over the telephone, using a number he found because I finally wrote him a letter he was actually allowed to read. I watched that land on Richard's face the way a verdict lands on a defendant who has spent the entire trial convinced of his own acquittal. A slow, cold understanding that the story he had been telling himself and everyone else for 12 years had just been directly contradicted by the one person in the family whose testimony he could not discredit. Ethan stepped forward then, cap still under one arm, his gown slightly rumpled from the ceremony, and positioned himself quite deliberately between his family and me. Not as a wall exactly, but as something closer to a bridge, one hand resting lightly on my shoulder. "This is my grandmother," he said, and his voice, though young, carried the particular steadiness of someone who had decided, in that instant, exactly where he stood. "I invited her. I've been talking to her for 3 weeks. And before anyone says anything else, I want everyone here to know that the summer program that got me into law school in the first place, the one I've been telling this whole family changed my life, that was her. She funded it, anonymously, for years, because none of you would let her do it any other way." I had not told him that detail directly. I want to be honest about that because it surprised me as much as it surprised his family, standing there on that lawn. It turned out that the attorney who administered my father's trust had done exactly what the instrument required of him, and not one word more, delivering the beneficiary a full written accounting in the year before his interest was due to vest. Ethan had read every page of it twice, matched the dates against a summer program he remembered better than anyone, and worked out the rest entirely on his own. He had inherited more of his great-grandfather's patient thoroughness than any of us had realized. I want to describe, slowly, exactly what happened in the seconds after Ethan spoke, because I have relived those seconds more times than almost any other moment in this entire story, and I think they deserve to be told with the same care I have tried to give everything else. The reception lawn, which had been humming with its own low chatter only a moment before, went almost perfectly still. Not silent exactly, because a string quartet somewhere behind the tent kept playing, oblivious, and somewhere further off a child laughed at something that had nothing to do with any of us. But the small crowd gathered near the reception line seemed to collectively hold its breath, the way a courtroom holds its breath in the half-second between a jury foreperson standing up and the verdict actually leaving their mouth. I noticed, in that stillness, a woman in academic regalia standing just behind Richard's wheelchair, a lanyard with the university seal still around her neck, and I recognized her, after a moment, as the dean who had presided over the ceremony less than an hour earlier. She had drifted toward our small gathering the way administrators often drift toward any disturbance at their own events, equal parts concern and curiosity. And I watched her expression shift as she caught the tail end of what Ethan had said. "Judge Callahan," she repeated quietly, almost to herself, and something in the way she said it, with a small note of genuine recognition rather than confusion, told me she knew exactly who I was. Likely from a continuing legal education panel I had spoken on the year before, or from one of the handful of appellate opinions I had authored that occasionally found their way into first-year casebooks. "I didn't realize you were Ethan's grandmother," she said, turning toward me with an expression caught somewhere between professional respect and simple human surprise. "We were genuinely honored you attended today, though I confess I had no idea there was a family connection." I watched that small exchange land on Daniel's face with its own particular weight, separate from everything else crashing down around him in that moment. It was one thing, I think, for his own mother to reappear after 12 years and announce a name he did not recognize. It was another thing entirely to watch a university dean, a woman with no personal history in this family's private mythology, greet that same name with immediate, unforced respect. The kind of respect that cannot be manufactured or argued away in a courtroom, Because it had been earned, quietly, over a decade, in rooms none of the Whitfields had ever bothered to notice I was standing in. Richard's hands, resting on the arms of his wheelchair, had begun to tremble, and I watched him grip the armrests more tightly, the old instinct to appear composed fighting visibly against a body that had simply stopped fully obeying him months earlier. "This is a family matter," he said again, louder this time, though his voice cracked slightly on the word family, betraying more than he likely intended. "Whatever my son's summer program was funded by, that has nothing to do with anyone standing on this lawn except the people who belong to this family." I felt something harden in my chest at that word, belong. The same word he had wielded against me 12 years earlier in that study. The same quiet violence dressed up in the language of ordinary conversation. "You used that word to me once before, Richard," I said, and I let my voice drop lower rather than louder, because I had learned, over years on the bench, that a courtroom quiets faster for a lowered voice than a raised one. Belong. You told me I would never truly belong to this family, that I had been let in on sufferance, and that sufferance could always be withdrawn if I became inconvenient enough. I became inconvenient the moment my father's trust named me sole trustee, instead of handing that authority to your firm. I have thought about that word for 12 years, Richard, and I want you to know that I finally understand it completely. You were right. I never belonged in this family. I belonged to something better, and it simply took me a decade to find my way back to it. Vanessa opened her mouth as though to interject, some reflexive legal instinct reaching for objection, but nothing came out, and I watched her instead turn toward her father with an expression I had never once seen on her face in all the years I had known her as a child. Something close to genuine uncertainty. She had built her entire professional identity on being the sharpest person in every room she entered, and for the first time in her adult life, she appeared to have no idea what argument might actually help her here. Ethan's hand remained steady on my shoulder throughout all of it, and I found myself, in that strange, suspended moment, thinking not of the trust, not of the case building toward Monday, not even of the 12 years of silence, but simply of the small weight of his hand, warm and certain, the first physical proof in over a decade that someone in this family had chosen, deliberately and without any legal or financial incentive, to stand beside me. I want you to understand that of everything that happened on that lawn, that single detail, a 24-year-old's hand resting on his grandmother's shoulder, mattered to me more than any document, any trust, any reckoning still waiting 2 days away. Dorothy Kessler's sentence came back to me whole, standing there on that grass. Being needed is not the same as being loved. For 35 years I had been needed in that family, every single day, and I had let myself call it the other thing. That hand on my shoulder was the other thing. Everything else was justice. That was love, offered freely, for the first time since a process server had rung our doorbell on a cold February morning. A small crowd of Ethan's classmates had begun to gather at the edges of our circle by then, the particular curious drift of young people who sense, instinctively, that something important is happening, even when they cannot yet name what it is. A few of them had phones half-raised, not recording exactly, but poised, the reflexive habit of a generation that has learned to document first and process later. And I remember thinking, with a strange, detached clarity, that whatever happened in the next few minutes might not stay contained to this lawn for very long. Richard tried once more to reassert the old order, the way a man reaches for a tool that has served him his entire life without ever once considering that it might have finally stopped working. Eleanor, he said, and there was something almost pleading beneath the remaining authority in his voice. You have made your point. Whatever you funded, whatever title you've earned, none of that changes the fact that this family made its decisions 12 years ago for good reason. You were not well. Everyone here remembers that. I felt the old wound flare at that sentence, sharp and immediate. The particular pain of hearing a lie repeated so many times that its speaker has genuinely come to believe it as fact. No one here remembers that, Richard, I said quietly, because it never happened. I was never unwell. I was inconvenient. There is a difference, and I think, somewhere underneath 50 years of practicing law, you have always known exactly what that difference is. I watched him search for a rebuttal and find nothing, his mouth opening slightly and then closing again. The same silent collapse I had watched overtake Daniel only minutes earlier. And I understood, standing there in the golden afternoon light, that I was witnessing something I had waited 12 years to see, without ever quite letting myself believe it would arrive. Not cruelty answered with cruelty, simply the quiet, inevitable collapse of a story that had never been true, finally meeting a room full of people who could see it clearly for the first time. It was in that exact silence, thick and trembling at the edges, that Vanessa finally found her footing again, reaching, as I had known she eventually would, for the one tool a lawyer always reaches for when personal ground has given way entirely beneath her. Facts. Documentation. The comforting architecture of procedure, the last solid thing she believed she could still stand on. 12 years of disbursements, Vanessa, I said. Every one of them lawful. Every one of them documented to the penny. Not one of them through your firm. Vanessa's champagne flute finally slipped from her fingers, shattering quietly against the grass, and no one moved to clean it up, because every single person standing near that reception line had suddenly stopped caring about anything except the sentence that had just been spoken. That's not possible, she said, and I heard, for the first time in this entire encounter, real fear underneath her lawyer's precision. We would have known. The firm handles trust distributions for half this county. We would have seen the paper trail. You would have seen it, I said, if you had ever once thought to look for a Callahan trust instead of a Whitfield one. My father built that trust specifically so that no one with your surname could touch it, or trace it, or control it, until Ethan turned 25. He understood something about this family a long time before I was willing to admit it myself. I watched Daniel's face as I spoke, watched him do the mental arithmetic every managing partner eventually does when a number they didn't expect enters a room. And I saw the exact moment he arrived at a second, far more dangerous calculation. Wait, Daniel said slowly, and something in his voice had changed entirely. The confident dismissal of 90 seconds earlier replaced by something closer to dread. The building. Our offices. The lease renewal came through a holding company we could never fully identify, some kind of legacy ownership structure from before the original lease was signed. Mom, please tell me that's not... He did not finish the sentence, but he did not need to. I watched him arrive at the answer on his own. The same way a defendant sometimes arrives at his own guilty verdict several beats before the jury foreperson speaks it aloud. The building your firm has leased for 30 years, I said quietly, sits on a controlling minority stake Walter Callahan bought before you were born, Daniel, and wrote into a trust no one carrying your surname was ever permitted to touch. Upon Ethan's 25th birthday, that stake transfers entirely and irrevocably to him. Your father spent 12 years telling anyone who would listen that I was unstable, that I couldn't be trusted with money, with judgment, with anything of consequence. And for 12 years, your family has been paying rent, indirectly, into an inheritance that was never yours to control, and was always, eventually, going to belong to the one person in this family none of you ever thought to disown. I want to tell you that I felt triumphant delivering that sentence. And part of me did. A small, private human part that 12 years of injury had earned the right to feel. But mostly, watching Richard's hands tremble in his lap, watching Daniel's carefully constructed composure finally, completely collapse, I felt something closer to exhaustion. The particular exhaustion of a woman who had spent over a decade proving, meticulously, patiently, that she had never been the broken thing they said she was, and who had finally run out of anything left to prove. It was Richard who spoke next, his voice thinner than I remembered, stripped of every ounce of the courtroom command that had once filled entire rooms without effort. "Eleanor," he said, "we can discuss the trust matter privately. There's no need to make a spectacle of a family disagreement at our grandson's graduation." And there it was, the old instinct, even now, even diminished, even caught, reaching first for containment, for the careful management of appearances that had defined every single year of our marriage. "A family disagreement," I repeated. "Is that what we're calling it now, Richard? For 12 years, I believed you called it something else. Unfitness, instability. I believe the exact phrase you used, in your study, 4 months before the papers arrived, was that I was never fit to be a Whitfield." I let that sentence sit in the air over the reception lawn for a long moment. Long enough for every guest within earshot to understand exactly what kind of story they had unknowingly wandered into. You were right, Richard. I stopped being fit to be a Whitfield the day I decided to become something better instead. Vanessa, scrambling now, reached for the only tool a lawyer reaches for when the facts have turned hostile: procedure. "Even if any of this is true," she said, her voice climbing half an octave higher than her usual composed register, "you can't just show up unannounced and unravel someone's entire understanding of their own family in the middle of a graduation reception. There are ways to handle disputes like this. Formal channels. This isn't appropriate. This isn't professional. This isn't how any of us were trained to—" "I know exactly how we were trained to handle disputes in this family, Vanessa," I said, cutting through her rising panic with a calm that felt, even to me, almost surgical in its precision. Quietly, behind closed doors, with paperwork drafted by people the other party could never afford to fight. I lived inside that training for 35 years. I am not interested in repeating it now, and frankly, given what's arriving at your firm's offices Monday morning, I don't believe formal channels are going to be optional for much longer. The silence that followed that sentence had a different quality than everything before it. Sharper, more frightened, because I watched both Daniel and Vanessa understand, in the same instant, that I had just referenced something neither of them yet knew about. "What's arriving Monday morning?" Daniel said slowly, and I heard, underneath the question, a managing partner's dawning terror at the shape of a threat he could not yet fully see. I did not answer him directly, not yet, because that particular reveal belonged to Marcus, to due process, to a system I had spent a decade of my life helping to build with integrity, precisely so that it would never be weaponized the way this family had once weaponized its own private version of justice against me. "I would encourage you to speak with your firm's outside compliance counsel first thing Monday morning," I said instead, "before the mail arrives. I think you'll find the conversation more productive if you're not caught entirely by surprise." I turned then toward Ethan, whose hand had never left my shoulder throughout the entire exchange, and I felt, for the first time in 12 years, the particular relief of being seen fully by someone who mattered, without a single wall of pretense standing between us. "I think," I told him gently, "your family and I have quite a lot to discuss, but not today. Today belongs to you." Behind us, I heard Richard's aide quietly ask if he needed to sit somewhere shaded, and I understood, hearing the exhaustion in that simple caretaking question, that whatever remained of this confrontation would need to continue on another day, in another room, with cooler heads and clearer paperwork. Monday morning arrived exactly the way I had promised it would, though I learned the details secondhand through Marcus, and later through the careful public record of a disciplinary filing that took less than a week to become the single most discussed piece of legal news in the entire county. The State Bar's formal complaint against Whitfield and Associates named Daniel as managing partner and Richard as the firm's senior partner emeritus, alleging systemic commingling of client trust funds spanning nearly a decade, totaling, in the final forensic accounting, just under $2,100,000. The local paper ran the story on its front page, above the fold, with a photograph of the firm's frosted glass door and its brass letters, the same door I had walked beneath 100 times as a young wife carrying trays of hors d'oeuvres to holiday parties. The headline did not mention me at all, and I found, reading it alone in my kitchen that Monday evening, that I did not need it to. Some victories, I have learned, do not require your name in the headline. They only require the truth, finally, to be the one thing left standing in the room. The collapse, once it began, moved with a speed that startled even Marcus, who had spent 3 years building the case with a patience I recognized intimately as my own. 3 of the firm's junior partners resigned within the first 10 days, each one quietly informing local clients that they would be establishing independent practices, a professional courtesy that was, in reality, a lifeboat launching before the larger ship finished sinking. 2 long-standing corporate clients terminated their retainer agreements within the month, citing, in careful legal language, concerns about fiduciary reliability, a phrase that, I imagine, tasted particularly bitter coming from clients Daniel had personally courted for over a decade. I want to be honest with you about something, because I think it matters for understanding the woman I had actually become, rather than the woman this story might tempt you to imagine. I did not celebrate the firm's collapse. I did not pour myself a glass of wine and toast to their ruin, the way I imagine a colder version of me, forged entirely out of grievance, might have done. What I felt, mostly, watching that story unfold from a careful, ethical distance, was a complicated kind of grief, because the firm that was collapsing was also the place where I had once hosted 35 years of holiday parties, where I had once believed, with my whole heart, that I was building something permanent with people who loved me. Richard's health, already fragile, declined sharply in the months following the filing. I learned, through Ethan, who had become, almost overnight, the family's unlikely bridge back to me, that his grandfather had suffered a series of small strokes in the weeks after the reception, brought on, his doctors believed, by the stress of watching decades of carefully constructed reputation dissolve in a matter of months. I sent flowers to the hospital, not out of any lingering romantic attachment, that had died a very long time ago, but out of something closer to the exhausted mercy you extend to someone who taught you, indirectly, exactly how strong you were capable of becoming. Daniel called me himself, 3 weeks after the graduation, his voice on the phone smaller than I had ever heard it, stripped entirely of the confident dismissal he had greeted me with on that reception lawn. "I need to ask you something," he said, "and I need you to be honest with me, because I don't think anyone in this family has been honest with each other in longer than I can remember." He asked whether I had known, that day at the reception, exactly how devastating the timing would be, whether I had planned to detonate everything on the single day that was supposed to belong entirely to his son. I told him the truth, because I had promised myself, standing in that motel room outside Latimer County 12 years earlier, that I would never again become a woman who managed the truth for someone else's comfort. "I didn't plan the timing, Daniel," I said. "I promise you that. I planned to attend my grandson's graduation because he asked me to, and the rest of it, the filing, the investigation, arrived on its own schedule, built by people who were doing their job correctly for the first time in a decade. If the truth happened to arrive on the same day I did, I think that says something about how long overdue it already was." There was a long silence on the line, long enough that I wondered if he had hung up, and then he said something I did not expect, something that told me, more than any apology could have, that at least one member of that family had inherited a genuine capacity for self-examination. "Dad used to say you were never fit to be a Whitfield," he said quietly. I used to believe him, because believing him was easier than asking questions I was afraid of the answers to. "I don't know how to undo 12 years, Mom. I don't even know if I'm allowed to call you that anymore. But I'd like to try, if you'll let me." I did not answer him right away, because I have learned, over 12 years of rebuilding myself from nothing, that forgiveness offered too quickly is rarely forgiveness at all. It is simply relief wearing forgiveness's clothing. "You can call me Mom," I finally said. "But Daniel, I need you to understand something, and I need you to actually hear it this time, not just process it the way you process a difficult witness on cross-examination. Trust isn't a verdict. It isn't something a jury hands down in a single afternoon. It's something you rebuild the same slow, patient way I rebuilt everything else, one honest conversation at a time." Vanessa's path back was slower, and in some ways remains unfinished even now, because pride, I have found, dies harder in people who have spent their entire lives being told their competence was their most defining feature. She left the firm entirely within the year, not disbarred, her own individual conduct having remained, mercifully, within the bounds of the law, but unable to remain in a building whose reputation had become, overnight, a professional liability rather than an asset. She opened a small solo practice 2 towns over, family law, ironically enough, and I have heard, through Ethan, that she has become quietly, meaningfully good at helping clients navigate exactly the kind of family estrangement she once helped orchestrate against her own mother. Richard passed away 18 months after the graduation, in a care facility 2 counties from the house we had once shared. And I attended the funeral, quietly, in the back row, the same seat I had once occupied at his grandson's ceremony. I did not speak at the service. I did not need to. I simply sat with the complicated grief of having loved and been genuinely wounded by a man whose final years had taught him, too late for either of us to fully benefit from the lesson, that control and love are not, in fact, the same instrument, no matter how convincingly a courtroom voice can make them sound alike. Ethan graduated with honors, passed the bar on his first attempt that same summer, and did something that surprised absolutely no one who had watched him grow, in those brief, precious years, into a young man who had inherited far more of his great-grandfather's quiet integrity than his father's courtroom instincts. He did not join what remained of Whitfield and Associates, which dissolved entirely within 2 years of the filing, its assets liquidated, its clients scattered to a dozen smaller practices across the county. Instead, he clerked for a year under a federal judge and then accepted a position with the very disciplinary counsel's office where Marcus still worked, choosing, quite deliberately, to spend his career on the side of the law that protects people like the elderly clients whose trust accounts his own family had once quietly violated. When his controlling stake in the office building transferred to him on his 25th birthday, precisely as my father had designed it to, in a paragraph he had written while Ethan was still a boy in grade school, he made a decision that I think would have delighted Walter Callahan more than any courtroom victory ever could. He converted the ground floor of that building into a free legal aid clinic, staffed partly by volunteer attorneys, serving exactly the kind of clients whose trust his own family's firm had once betrayed. He named it, without asking my permission, and without warning me until the ribbon-cutting ceremony itself, the Callahan Legal Aid Center. I stood in the crowd that day, in my charcoal suit, and I cried in a way I had not allowed myself to cry in over a decade. I want to close this story the way I have tried to live the last 12 years of my life. Honestly, without dressing up the ending in more triumph than it actually deserves. My relationship with Daniel is real now, rebuilt slowly, carefully, over dinners where we have learned to sit in uncomfortable silences instead of filling them with performance. My relationship with Vanessa is still finding its footing, and I have made peace with the possibility that it may never fully arrive at the place I once hoped for. Because some walls, once built high enough for long enough, simply take longer to come down than a single lifetime allows. But my relationship with Ethan, the boy who grew up believing an anonymous stranger had changed his life, and became a man who chose, entirely on his own, to spend his career protecting the exact kind of people his family once harmed. That relationship is the truest, most complete thing I have built since the day a process server handed me a manila envelope on my own front porch. If there is a single lesson I would ask you to carry away from this story, it is not the satisfaction of watching a family of lawyers finally face the consequences their own arrogance had been quietly accumulating for a decade. Though I will admit, there is a certain justice in that. It is this, instead. The people who call you unfit, unstable, unworthy of belonging, are very often simply describing their own fear of what you might become if you ever stopped believing them. I spent 35 years shrinking myself to fit inside a family that had already decided how much space I was allowed to occupy. Dorothy Kessler handed me the truth of it in the rain, with a warm dish in her hands, and it took me most of a lifetime to hear her properly. Being needed is not the same as being loved. That house needed me every single day it had me, and I mistook the needing for the loving, because not one person inside it had ever shown me the difference. It took losing everything, and 12 patient years of rebuilding myself, one law book, one birthday letter, one quiet trust disbursement at a time, to understand that the space I was afraid to take up was never actually theirs to allocate in the first place. Have you ever been made to feel like a stranger inside your own family? Like your worth was something other people got to decide and hand down like a verdict? I would love to hear your story in the comments below, whatever shape it takes, because I have learned, more than anything else in these 12 years, that none of us carry these wounds alone, even when the silence makes it feel that way. And if this story meant something to you today, I would be so grateful if you would take a moment to like this video and subscribe, so that the next story finds you when you need it most. Thank you, truly, for staying with me until the very end.